Welcome back to India Tonight. We're discussing the Mathur doctrine of judicial.
But there are some judges or some benches of some high courts, some judges, some benches of the Supreme Court that have sometimes gone a little off the mark. But that is not to say that we should, in one fine sweep, take it all away. Because, Karan, one very important aspect of our constitution, and we are a country governed by a written constitution, is that the higher judiciary is placed almost at the highest level of governance. Now, judicial governance is to be found in the various articles of the constitution, in the various powers that they exercise, in the writs that they issue, and so on. And therefore, I don't think that one should take away the plenitude of the power of the court and assimilate it to some odd people doing odd things at odd times.
Let me approach that same question, Mr. Sorabje, and put it like this to you. Do you agree that judges have no real business entertaining cases connected with matters such as nursery school admission, cleaning up slums, or demolition of buildings? Or would you say that these are issues that have to be decided case by case rather than by means of a general law or principle?
Now, first of all, let me say I quite agree with Pali. And nursery school and other issues will have to be decided depending on the facts of the particular case. And what I find most unfortunate about these totally gratuitous observations made by Justice Karchu and his brother judge in a matter which was not a PR matter, which arose in a civil suit in an appeal, and he has just gone off at a tangent and also made observations which would affect the fate of the matters pending in the Delhi High Court. Now, the judge bench had no business to do that. If he was giving a lecture at the Indian Law Institute, that's all right. And he has gone on. Who argued the other point of view? He has referred to judgments of the US Supreme Court, which are dissenting judgments. He has referred to other judgments which we have not accepted. And he has given in the one sentence, he has completely, all the sound and fury goes, because he says, judicial activism at times is an adjunct to constitutional democracy. Oh, okay. So what happens to that very important judgment on sexual harassment, where Justice Verma, whom he admires very much, laid down what the law of sexual harassment is, what is the procedure, what's the definition, what happens? What happens to that? Is that unconstitutional?
Okay. Let's pause at that moment, Mr. Nariman, and let's look at a key part of Justice Mathur and Justice Karchu's judgment. And let me read out this key quotation to you. Judges must know their limits and must not try to run the government. They must have modesty and humility and not behave like emperors. And then critically it adds, if there is a law, judges can certainly enforce it, but judges cannot create a law and seek to enforce that. Would you agree with that, particularly the last bit?
Let me just throw at you another quote from another person very high up in the judicial hierarchy in the world. Chief Justice Roberts of the US Supreme Court said this, and just listen. Judges must be constantly aware that their role is limited. They do not have a commission to solve society's problems as they see them, but simply to decide cases before them according to the rule of law. Aptly put, simply put. And I would agree with it. But this was not said in a judgment of the US Supreme Court, of which Roberts is the head. It was said outside the court. So there is a time and a place and an occasion for saying things of the nature that you have just quoted, or what I have quoted. But in India, when you pontificate on this and say it on the bench, and not when you are in mufti at a seminar, it is apt to be construed as laying down law, because Article 141 of our Constitution says that the law declared by the Supreme Court is binding on all courts in the country.
But looking beyond just the point that you've heard, Mr. Sorabje, that this was the wrong occasion to make this sort of point, what about something else? Don't judges frequently actually create laws and enact them? You mentioned the judgment of Justice Verma. Let me mention another judgment. Justice Verma in the Jain Hawala case laid down the law for the appointment of the CBI director and also placed the agency itself under the supervision of the Central Vigilance Commission. I believe his successor, Chief Justice Anand, laid down the procedure for determining how policemen should carry out arrests. Both these judges were applauded for what they did, and yet under the Karan-Mathur philosophy, this would have been impossible to do.
Yeah.
Yeah, but so is the two judges of the Supreme Court wrong in saying that judges mustn't seek to create and enact law?
Is it for me to comment?
Yes, yes, absolutely.
In the first place, I don't regard these observations as laying down the law at all under Article 141. They themselves said they decided the case which came from Punjab and Haryana and then made these observations. These are not even considered arbiter observations. I've called them gratis dicta. Just for the purpose of whose benefit and whose erudition I don't know. And what I want to say is this, that where is freedom of the press mentioned in our Constitution? How do the judges get it? Isn't the right to everyone be a law of the right, say it's indispensable to democracy? They deduced it from the free speech guarantee. Where is the important right of privacy as a constitutional right, as a fundamental right? Again, the judges deduced it. And that is what has been done even in America, even in Ireland, the Republic of Ireland, and that's the technique which judges use to creatively interpret. And mind you, it's a childish fiction. No one believes that judges don't make law at all. They do. Even Justice Holmes said, interstitially maybe, but not in cases where relating to economic matters, military matters. That's a different matter. And our judges have not. In the Balco case, they have said very clearly, we will not interfere even if the policy is unwise, uneconomic, unscientific.
Would you accept that in certain specific instances, ruling out economic cases and military cases, the law does require judges to often creatively interpret statutes, and that in turn does lead to some form of creating new law and enforcing it? That's part of complete justice. And therefore, the Karan-Mathur philosophy is circumventing and precluding that whole area of jurisprudence.
Let me read out to you what came in the newspaper this morning. Another judgment by another two-judge bench. And the headline reads, Spare Sabarmati Ashram from road planning. Now, road planning is something which the administrators must do, not the courts. Now, here was a vast area of Sabarmati Ashram through which a road was to be planned. There was a writ filed that it should be prevented, and ultimately the Supreme Court said, yes, particularly you must preserve this sort of heritage of Gandhiji and let us not have it. The government didn't do it. Would you call this naked usurpation of executive power?
Presumably Karan and Mathur would.
Now, but that's the problem.
And they'd be wrong if they did so.
They'd be wrong if they did so.
Let's come to the defense and the arguments that Karan-Mathur put forward for their particular philosophical viewpoint, Mr. Sorabje. They say they won't accept the justification that when the legislature and the executive aren't functioning properly, it's the duty of the judiciaries to step in. And they say it's for the people to correct the defects by exercising their franchise properly in the next elections and by electing candidates who will fulfill their expectations. Do you accept that justification?
No. As far as the executive is concerned, certainly not. Because what the Supreme Court says is, to the executive, you made these laws, please enforce them.